Hello, this is attorney Noreen Barcena. If you are seeing this video, it's either because you happened to come across it or it was sent to you by our office because we've reached the next step. And what is the next step? Well, this video is going to be about how to do a 601A waiver when you are living inside of the United States and you have accrued unlawful presence. Because in your case, we are doing what's called the consular process because you did not enter the United States legally, or you have a removal order that's going to require a 601A waiver and a 212 waiver. Now, a 601A waiver is a waiver that's done because you have accrued what's called unlawful presence. After April of 1997, when someone lives in the United States without status, each day after they turn 18, they begin to accrue what is called unlawful status. If a person accrues unlawful status for more than 1 year, then once they leave the United States, they trigger what's called a 10-year bar. So the 601A waiver is something that addresses that 10-year bar. You will leave the United States knowing that you have a waiver to waive your unlawful presence. It's kind of like saying, hi, I'm eligible to become a legal permanent resident at my consular post in my country of origin, but I've been living in the United States unlawfully, and so I'm asking that you forgive me. Now, the people that qualify for 601A waivers are people that have U.S. citizen or U.S. resident spouses or parents, or legal permanent resident spouses or parents. And typically we're talking about a U.S. citizen spouse and a non-U.S. citizen or resident spouse. What I mean is it's a person that is immigrating into the United States and needs a waiver. So now that we've already done the I-130, proven that your marriage is a valid marriage or the relationship is a real relationship, and it's been sent to the National Visa Center, the next step, along with doing the documents required for the National Visa Center, is sending out a 601A waiver. And what is it that we need for a 601A waiver? Well, we need to prove that the qualifying relative, which is the U.S. citizen parent or spouse or LPR parent or spouse, is going to suffer an extreme hardship if you are not able to remain in the United States. And typically what my office likes to look for is we ask for economic information, medical information, information about the country of origin and why the family cannot be split up. So we're going to be asking you to bring to our office, scan to our office, or upload to MyCase documents related to bills for the last 6 to 12 months, tax returns for the last 2 to 3 years. We also are going to ask for proof of income. That will address the economic factors. If you can prepare a budget for us, that will also be helpful to show, one, why you two depending on each other, or two, why the family cannot be split up because you cannot be able to sustain two households, one in the country of origin and one in the United States. In terms of medical issues or emotional health issues, what we're looking for is a psychological evaluation. If you already have a therapist, then show proof that the U.S. citizen or LPR qualifying relative periodically goes to therapy, is suffering from some sort of ailment, or needs extra assistance. Some common things that happen, for example, is that a person will get anxiety or suffers from depression, and the thought of being apart can exacerbate that or make it worse. And so that's what we're trying to prove. If you don't have someone that can do the waiver for you, if you don't have a psychiatrist or a psychologist that can do the report for you, then we will refer someone for you to go to, because what we need is for a licensed therapist or a licensed MFT or social worker to give us a report, giving us a diagnosis, a prognosis, and explaining to the officer why the family should not be or cannot be separated and what is the U.S. citizen or legal permanent resident suffering from. Also, what is important is if the LPR or US citizen is suffering from some kind of medical issue, high blood pressure, or some sort of other serious illness, such as hyperthyroidism, cancer, whatever the case, we will need medical records. It's very important. Now, some things that we also look at is family ties. We want to also prove that the non-citizen, the person that's becoming a resident, has good moral character. So we'll be asking for letters from family and friends talking about the relationship, why the couple needs each other, or why the parent needs the child, and what would happen without that person here in the United States. If the application is done by a spouse to a spouse and there's children involved, then we'll also take any medical records from them as well. Because what we want to do is look at the totality of the circumstances or the entire picture. Now, if you have any other questions, do not hesitate to call our office. It is an important process to the next step. The USCIS processing times can be looked at on the website, and at this stage it is 2026. They take anywhere from 4 to 6 years to process the 601A waiver, which, yes, unfortunately that is a long time, but it is an important process. So remember, what we're trying to prove is that there is a hardship to the US citizen or LPR spouse or parent. And so make sure you get those documents over to our office or to your attorney if you are just looking for information on what is a 601A waiver. So if you have more questions, remember, we're in Pasadena, 626-898-7200. And thank you for watching.